Hi, my name is Fiona Lyon and I'm a partner at Anthony Gold Solicitors, and today I'm going to be talking to you about the fascinating subject of surrogacy law. So surrogacy arrangements date back to biblical times but gained real momentum after 1978 when the first baby was conceived by IVF. This pioneered further medical advances, and in 1982 the first baby was born via egg donation, with the first gestational surrogacy being achieved in 1985. Surrogacy gained bad press early on following the controversial surrogacy case of Baby M in the US in the mid-1980s. This was a case where the surrogate had a biological link to the baby and refused to give up parenthood following the birth. A 2-year custody battle ensued, with the intended parents being granted custody and the surrogate having visitation rights. This is fortunately a rare occurrence. Surrogacy arrangements have gained further prominence, with stars such as Elton John, Robbie Williams, Sarah Jessica Parker and Kim Kardashian extending their family in this way. The growth of surrogacy arrangements has therefore increased dramatically over recent years, with the oldest recorded surrogate being aged 61 and giving birth to her own grandchild. There are many reasons why people turn to surrogacy, which include failed IVF procedures, recurring miscarriages, pregnancy health risks, premature menopause or internal abnormalities. These types of arrangements are also very popular in the LGBTQ community, and they allow a genetic link to be created to a child where otherwise it might not have been possible. There is some essential terminology which I'll just go through now, and that is to call the parents to be intended parents or IPs. The surrogate should always be called a surrogate. They should never be called mother or parent. Gestational or host surrogacy is where the surrogate has no biological link to the baby and the embryo is created by the IP's gametes or with assistance from a donor. Straight surrogacy is where the surrogate will use her own egg and the IP's sperm or donor sperm. Commercial surrogacy is where the surrogate is permitted to be paid compensation to carry a child in addition to expenses. This is legal in the US but is not legal in England. Surrogacy arrangements are the documents that are signed by the parties involved to record their intentions and commitment to the process, and I'll talk about that a bit later. Parental orders are the court order that transfers legal parenthood from the surrogate and potentially her husband or civil partner to the IPs. This is different to adoption, where you're effectively replacing parenthood. This is more of a transfer of parenthood. So now we're going to turn to look at the actual pathway that parents-to-be go through to get to surrogacy. Surrogacy in England is legal, but the surrogacy arrangements themselves are not legally binding or enforceable. Under the Surrogacy Act 1985, it is a criminal offence to advertise for a surrogate, negotiate a commercial arrangement with a surrogate, or facilitate surrogacy for someone else. It's also a criminal offence for a surrogate to advertise surrogacy services. In order to minimise risk, it is therefore recommended to proceed via an experienced surrogacy organisation and enter into a surrogacy agreement that way. The 3 largest agencies are Brilliant Beginnings, Surrogacy UK and COTS, which is COTS. These organisations help intended parents to find a surrogate and conduct background and medical checks to ensure the right candidates are found and matched. It's important for the IPs to develop a relationship of trust with the surrogate and to get to know each other properly before any surrogacy agreement is reached. Surrogacy agreements are likely to include the following: conception arrangements, which means how the embryo is to be created and inseminated. If the parties require IVF treatment, further decisions will need to be made, such as a choice of clinic, how many embryos should be transferred at a time, and various other matters. We also need to look at the pregnancy arrangements, which includes the medical decision making if something goes wrong, healthcare throughout, which looks at what medications and vitamins should be used, who will attend appointments, and how much information the IPs will be given during this waiting period. Birth arrangements are also very important, which outlines the type of birth, medications and who will be present. Post-birth arrangements, in other words, how will the baby leave the hospital, and it's important to agree discharge arrangements with healthcare staff so the IPs are properly recognised. Expenses, again, this is very important. It's very good practice for a surrogate to provide an estimate of reasonable costs up front and for it to be recorded in the agreement. Surrogate is also permitted to be reimbursed for loss of earnings, treatment costs such as IVF, additional childcare to cover appointments, travel costs, additional food and supplements, additional therapies that assist the pregnancy, modest recovery break with her family afterwards. These payments are going to be scrutinised by the family court when it comes to making the parental order, and the surrogate must keep a record. In terms of wills, that is also very important because most IPs would be recommended to make one so that guardianship is considered in the event of death of one or more of the IPs. The IPs will want to nominate carers to ensure the surrogate and the child are protected, as remember, the surrogate is not opting into being a parent of that child. Thank you for listening to my talk today. And if you have any queries in relation to surrogacy arrangements or international surrogacy arrangements, please contact me at Anthony Gold, and my email address is fjl@anthonygold.co.uk. Thank you.